I've noticed that the Honourable Pete Hodgson is in the House without a tie. Now, I raise this point not to castigate the Honourable Member. If I could just be heard, Mr Speaker, on this.
Thank you. I think the member is correct. I just asked the member, is it standard business attire is what's required, which includes a tie. Thank you.
Mr Speaker, I hadn't actually finished my point of order. I was...
no, I knew what the... I knew...
No, you don't, sir. With respect...
Order, please. There is a point.
I thought that Mr Hodgson may, in fact, be testing the boundaries, because I've consulted Speaker's rulings, and indeed, sir, as you say, Speaker's ruling 16.8, the Speaker will take issue with any member who is not dressed in appropriate business attire. I think there's actually a very good case to be made that these silly things that men are required to wear traditionally are no more. And I say that, sir, because my legal colleagues at large law firms now routinely do not wear them.
I thank you for that very enlightening example of what ties are about, but I have ruled, and you brought it to my attention. I thank you for that. We'll move on with the debate, and I call Keith Locke.
Thank you, Mr Speaker. I think Mr Garrett actually has a point that we should be moving to a broader dress code, and perhaps as a transition we could have a 90-day probationary period where people wear ties, and then after that they can go without the ties. And just to reply to Tohanari's comments, the question isn't whether you have trial periods or probational periods or not. It's a question of what type. And the type that Tohanari referred to in the past were really the type...
Point of order, the Honourable Tohanari.
Mr Speaker, we have just come out of Māori Language Week. And I wouldn't mind if my name was pronounced Tau Henare.
Oh, thank you for that. I'll just ask the member, when referring to a member, that we try and get the correct pronunciation. Thank you.
Thank you, Mr Speaker. My point was that Tau Henare's position was actually similar to what the Greens and the Labour Party have been arguing, that in the past, and even presently, there are probationary periods that are fair ones, that where you have a certain period and after that you can transfer to permanent employment, and if you aren't transferred, there's appeal procedures, the unions involved, etc., as they were in the past days that Tau Henare is referring to. Now, I think the point is that what are the arguments of the government in keeping this 90-day period? They are that somehow more people are hired, when in fact the research provided by the Department of Labour of the legislation since its introduction, they say it cannot be stated categorically that trial periods had created extra job opportunities. And that's common sense, really, because employers hire to need. They don't go down this track of scratching their heads for 10 minutes about the quality of the employees. And secondly, they argue that more young people get jobs this way too. And it's true that young people often have less CVs and find it more difficult in the job market. And David Bennett went on about this is what the bill's all about, the present legislation, giving workers a chance. Well, in fact, the situation with probationary periods, fair probationary periods that exist now in certain industries and in the past before this legislation came in, they do allow young people to have a go. And in fact, when you have an unfair probationary period where the employer has the arbitrary right to fire at any time without any reason, you have a charter for bullying in effect. The employer doesn't need to provide any care for the worker, for the employee, because they can go down the road at any stage. And that is really, Carmel Sepuloni mentioned the case in the Dominion Post of Alison Murray, who got this job as an art valuer for Dunbar Sloane and wasn't even given a desk to work at, and later on was just fired arbitrarily. It's also a charter for a greater level of sexual harassment in the workforce if the employer has arbitrary power over this new worker for 90 days. It's also a charter for dividing the workforce between those who are established and perhaps in the union and new employees who won't dare to join the union because a lot of employers are anti-union and would sack the person if they showed a great interest in joining the union. So it would divide the working force, and that is bad for morale. It's much better to have a united working force. Actually, a unionised working force, in my experience, is the most confident and productive working force, particularly if it's got a good relationship with the employer. Now, Kate Wilkinson, the Labour Minister, says, well, don't worry about all this. People are going to act, the employers are going to act in good faith. Well, you know, we just can't operate on the basis of that, and we have plenty of examples where employers have not acted in good faith in this respect. And if we generalise this 90 days, as the government says it's intending to do, that will actually have a lot of ramifications in the workforce. It will make workers much more reluctant to shift jobs because they won't be certain that they won't be sacked in the first 90 days. Migrants will be more reluctant to come to this country because they come here and then their job could go down the drain overnight. So I think that this is a bill that should be passed because it will reverse a very bad piece of legislation by the National Government.